Just as it has in other parts of the world, COVID-19 has put companies in the Central Eastern European region in challenging situations when it comes to intercompany pricing or the arm's length principle.
We have been living in these extraordinary circumstances for more than a year now. This short video summarizes what we have learned from our clients, from markets, and what companies have to focus in order to formulate the best responses to these challenges.
The pandemic brought greater focus to communication. Taxpayers want to know what tax authorities are thinking about intercompany pricing as regards the COVID-19 outbreak. Let's take a look at the situation in CEE. No formal local guidelines have been published in any CEE country. The tax authorities in some countries indicated that they accept and will follow the OECD guidance published in December 2020. In many countries, however, tax authorities shared their views during TP forums, webinars and APA negotiations, or posted a Q&A dialogue on their website regarding TP-related issues affected by COVID-19. Communications confirmed that tax authorities will consider the situation of each taxpayer on a case-by-case basis.
For example, the Czech tax authorities will look more carefully at the losses of local limited risk entities due to the COVID situation in 2020. The Hungarian authorities indicated that there can be room for comparability adjustments in line with the OECD transfer pricing guidelines, but only if these are justified. And for many countries, the APA regime is still available as a potential solution to agree with the tax authorities upfront for each particular case.
What are the main COVID-19 related TP issues in CEE today? Most CEE countries reported that so far the disruption has not brought major changes to their business model, with the exception of specific industries such as automotive, HoReCa, tourism, aviation, R&C, real estate. At the same time, many countries reported that the COVID-19 pandemic would have an impact on TP outcome, for example, potential operating losses or extraordinary expenses. Consequently, companies will have to consider the option for TP adjustments, especially limited risk entities. Also, entities need to consider potential changes to intercompany agreements.
In some countries, such as Romania, Poland, Hungary and Serbia, it was already confirmed that limited risk business models in most affected industries would very likely generate losses. In these difficult situations, financing becomes a key issue. Certain entities introduced cash pooling arrangements or new intercompany financing structures in order to secure their financial stability.
Having data means having power. Let's see what is required to prove the impact of the COVID outbreak on the company's operations.
Most important, the burden of proof is on the taxpayer. If a taxpayer indicates that COVID had an impact on its business, it will be expected to document it. No country-specific guidelines were published in any CEE country in this respect. Therefore, it is recommended to keep track of evidence, especially quantitative, of the impact of the pandemic on the company. Such evidence may include costs incurred due to activity lockdown, subsidies received, extraordinary expenses, the difference between actual and budgeted figures, evidence of behaviors of unrelated parties adapting to new reality and potential changes in the contractual terms.
Different examples in most of the CEE countries show that COVID-related information had to be provided in order to obtain government subsidies for employment protection, tax exemption or VAT payment deferrals. Such information included evidence on cancelled contracts, cancelled events or cancelled orders, as well as information on the number of the people affected by COVID or decline in the revenue.
What are the trends? What approaches are companies taking to maneuver themselves out of the breakdown caused by COVID-19?
There are no unified approaches to address COVID-related risks in transfer pricing policies. The practice is developing, but this is very much on a case-by-case basis, both in terms of the facts and circumstances of each taxpayer and in terms of the different tax authority approaches. However, based on our experience, what we are seeing are some common practices emerging. Certain groups that have been under pressure with managed margin entities have taken the decision to revise their target margin to the lower quartile or to zero for 2020 or 2021 purposes. However, with that, it's important to emphasize that in certain territories, the tax authorities have already indicated a reluctance to offer any allowances to accept loss-making results or to accept results below the lower quartile for the tested parties. Therefore, this needs to be considered very carefully.
Another approach is that companies are considering adjusting the benchmarking studies in order to reflect the challenges of 2020 in the transfer pricing rationale. In particular, the companies are considering the following: inclusion of loss-making companies into the final set, developing specific adjustments to the financial results of the tested party or benchmarking, perhaps linked to GDP trends, splitting a specific financial year into pre-COVID, during COVID and post-COVID periods, developing arguments to explain the losses due to exceptional external factors, usage of statistical data.
There are industries and companies heavily affected by the pandemic. COVID-19 produced not just losers, but winners as well. Both situations have their own challenges. We see the importance of communication and the possession of data, but from a transfer pricing point of view, it is very important to understand how significant economic functions change short and long term.